Oh, hello and welcome to our brief update on current developments in climate risk and ESG disclosure in Australia, United Kingdom and EU. My name is Brendan Bateman. I'm a partner in the Environmental and Sustainable Development team here at Clayton Utz. Joining me is my colleague Geoff Hoffman, who is a partner at Clayton Utz in our corporate team. I'm also delighted to welcome our colleagues from Travers Smith based in London, Simon Witney and Sarah-Jane Denton. Both Simon and Sarah-Jane have considerable experience in advising on corporate climate risk and broader ESG disclosure in the UK and EU. Now, Simon and Sarah-Jane, we know that the regulatory frameworks in the UK and EU are well advanced compared to some other jurisdictions, including Australia. I might ask if you could provide us with an overview of the current developments in those jurisdictions on corporate climate risk disclosure.
Yes, thanks, Brendan. Nice to be with you. The UK and the EU are both working hard on regulation of sustainability and are both placing significant emphasis on corporate disclosure as a policy intervention. Clearly, the view is that more disclosure will change behaviour. Whether that's true or not, we'll see. But they clearly think that disclosure is the way to go. Both of corporates and of investors. And perhaps they think it will also change the behaviour of other stakeholders too, that will in turn drive behavioural changes from corporates. So the EU is ahead of the UK in its legislative intervention, although most people acknowledge that the EU's haste has led to some significant missteps, which I think it's fair to say they're now trying to correct. For large corporates and asset managers, it's really the EU taxonomy that's going to become hugely important in coming years. This is going to require many EU-based companies to report the percentage of their activities which conform to a very specific EU definition of environmentally sustainable or green activity. Corporates, including many non-EU companies doing business in the EU, will also have a significantly enhanced sustainability reporting requirement to contend with in the coming years, something known as the Corporate Sustainability Reporting Directive, or CSRD, is coming on stream, which we'll talk about in more detail in just a moment. So that's corporates. Asset managers are also facing more disclosure requirements in the EU, including requirements to report the taxonomy alignment of their portfolio. That is the proportion of the investments in a portfolio that meet this taxonomy definition of green or environmentally sustainable activity that I mentioned a moment ago. But for asset managers, perhaps the best known, and I would say quite problematic reform for asset managers and other financial market participants has been the SFDR, or the Sustainable Finance Disclosure Regulation. And this, which as I say, applies to asset managers and other participants in financial markets, requires a wide range of disclosures by those asset managers. And in many cases, the requirements, what has to be disclosed, are not clear, and the underlying data is difficult or impossible to gather. So that's the EU. In the UK, which of course no longer part of the EU, the focus is similarly on disclosures, but the requirements are emerging more gradually, and they're different. So first, the UK has already mandated TCFD reporting across much of the economy. That's to say, reporting in a way that's consistent with the recommendations of the Task Force on Climate-Related Financial Disclosures, the TCFD. And this requires large corporates and most asset managers and asset owners to produce these annual TCFD reports. Again, we can talk more about those in a moment. The plan is to extend that regime, that disclosure regime, to cover other environmental and social issues using the TCFD framework and international accounting standards. But all of that's still in development, as is a UK version of the EU taxonomy, which will not be launched imminently, but which is planned. Finally, I would just say there's a move, I think, now to go beyond disclosure and towards mandating certain actions. Of course, that's not new. We've had anti-pollution, anti-corruption laws, forever. But what we're seeing, I would say now, is a move towards more general legal sustainability-related requirements. For example, moves in Europe to force companies to identify and then mitigate the adverse impacts of their activities, whether they be environmental or social adverse impacts, and to adopt net zero aligned transition plans to move their business model towards net zero. So that's what we're seeing. I said we'd say a few more words about some of those specific initiatives. Maybe Sarah-Jane, I could ask you to talk a little bit about CSRD and TCFD.
Great, thanks, Simon, and very happy to be here. So as Simon's trailed, the CSRD, or the Corporate Sustainability Reporting Directive, is the EU's flagship initiative in the world of sustainability reporting. On its face, it's just another reporting regime, but it's significant in two main ways. So first of all, it extends to organisations which aren't based in the EU, but which have significant turnover there. So if you make 150 million euros of turnover in the EU, and if you have a large subsidiary or a large branch there, you as an Australian or a UK or an other non-EU parent are the one that is responsible for sustainability reporting under this regime. So it's got some quite significant extraterritorial effect that's causing ripples. The second reason the regime is getting such a lot of interest is because what's reported under it is so broad and so deep. So standards are already being developed. We're still in draft at the moment, but we've got quite a good idea of what they're going to look like when they're finalised in the next couple of months. And we're not just talking here about climate reporting, which we're all starting to get our heads around, but these standards contain a wide range of ESG topics, including governance, social and human rights matters, and more traditional environmental topics like waste and pollution. What you're reporting on amongst those subject areas are the material impacts, risks, and opportunities, both to your business and of your business on those ESG matters. So that's a really important distinction, because most reporting regimes that we've worked with to date and that we're quite used to focus on the impact of climate, for example, on the financial performance of your business. This is known as double materiality, and the application of this standard is quite a deliberate and an important point of distinction between the EU regime and others, including the UK. So on top of that, if you're the parent that sits at the head of a consolidated group, you have to report for your entire group of companies on a consolidated business, regardless of how many entities that includes, where those entities are located, or how big they are. Even if you're not part of a consolidated group and you're just a large company with a lot of business in the EU, you have to report on what's known as your value chain. And this is quite a new concept that is causing us to scratch our heads a little bit. It's broader than just your supply chain because it includes entities downstream of your business as well. It would also capture, for example, investments and joint ventures that aren't technically within the perimeter of your corporate group. So as you can imagine, drawing the boundaries of your value chain is quite a challenge, and that's the next step for us in terms of the advisory work that we're seeing most of at the moment. So that's the EU, and as Simon said, it's taken the most interventionist approach and it's quite far ahead of the game. Turning to the UK briefly, there is quite a different approach here. As Simon said, the UK's adopted the TCFD framework, and that's mandatory for some parts of the economy, and there's ambition to roll it out very widely across the economy by 2025. You're reporting there on climate risks and opportunities to your business. So it's significantly narrower for now than the EU's regime. And many of you might be familiar with TCFD already. It has the benefit of being internationally recognised, and it does have mandatory application in some other parts of the world, including for some companies in New Zealand. The UK financial regulator, the FCA, has expanded the requirements somewhat for the firms that it regulates. These firms have to prepare a TCFD report at both the entity level and also at the level of each financial product that they offer. But the UK is also not standing still. It's not going down the same route as the EU, but it is moving its own reporting regimes forward. Proposals are out at the moment, which would require some financial entities to disclose on a much broader range of sustainability matters. The UK fully supports the ISSB standards on climate disclosures and sustainability, which we will mention in more detail in just a second. So just one small point of consolation in wrapping up. There is some overlap between these standards. So the EU body that's developed the new standards, which will apply for reporting under the CSRD, has worked with the ISSB to ensure that there is some interoperability between the standards. And similarly, it's covered off all of the TCFD reporting points in its draft standards. But as you might expect by now, the EU does want its own standard to become the gold standard and therefore the de facto requirement, and its standards are significantly wider as a result. So that's where we are in Europe and in the UK. And Brendan, perhaps you could give us an idea now of the state of play in Australia.
Yeah, great. Thanks very much, Sarah-Jane. That was a great overview. Appreciate you and Simon doing that. Look, the current state of play in Australia is that we don't have mandatory reporting obligations to the extent that corporates have disclosure obligations insofar as it concerns climate change or other ESG-related risks that arises from the general obligations that corporations and businesses have to disclose and report either in their financial reports or operating reports. So there's nothing specific at this point in time. We have had the regulators for several years now in Australia. By that, I mean the Australian Securities and Investments Commission, the Australian Prudential Regulatory Authority, all indicating very, very strongly that businesses need to seriously consider climate-related risks insofar as that they pose financial risks to their businesses and operations, and the need to understand, manage and disclose those risks insofar as it's appropriate in reports. I think last year, though, there was a significant development with the election of the Albanese Labor government in May 2022. Things are changing quite quickly, and in December last year, there was released by the Australian Treasury a consultation paper in relation to climate risk-related disclosures and reporting. The submissions in relation to that consultation paper closed at the end of last month, but it was fairly clear from the nature of the consultation paper that there will be a mandatory reporting regime in relation to at least climate-related risks in Australia. The door is open in relation to broader responsibility for reporting ESG-related and other social and environmental risks to businesses. But it's fairly clear that the TCFD, which is, as you've mentioned, Sarah-Jane, fairly well understood, and it's well understood in Australia and has been used by a lot of corporates as the basis for their disclosure reporting already, is at least forming the basis for a mandatory obligation in Australia. But there's also forward-looking. We understand that and Treasury made clear that the ISSB standards that have been developed and most likely to launch in the next few months are things that provide a further level of detail and a further level of comfort to a range of businesses, but in particular investors, about the quality of the disclosures that are going to be made. And that's one of the criticisms that's been made to date of disclosure reporting in Australia, is that there's significant inconsistency in the way in which businesses are disclosing and reporting their climate-related risks. So by adopting, hopefully, a consistent standard, one that's based on TCFD, but probably also being developed around expectation that the ISSB standards will also come and be something that's generally accepted. I think that that's where we're seeing things go in Australia. So the consultation paper that was released by Treasury really focused on the practicalities of implementing a mandatory reporting and disclosure regime. So what framework should be used? What are the reference points? And indeed, like I said, TCFD and ISSB both get mentioned in there, and seem to be a convergence around moving towards ISSB, or indeed just leaving the mechanism provided sufficiently flexible so as to accommodate ISSB in the future. There's also discussion around who it should apply to, not just ASX listed or funds, but including to large private corporates and government business enterprises also being caught within the regime. And then also the discussion around phasing in, how should it be applied, ensuring that Australia has the capability, and businesses in Australia have the capability to be able to actually report in a comprehensive way, something that is going to be not necessarily new, but in terms of the way in which it needs to occur, will be something that the resources and capability certainly does need to be built up in Australia over a period of time. So I think one of the things that is facing Australia in terms of addressing climate risk disclosure is some of the unique corporate regulation regimes that exist in Australia already. And therefore, where within our regulatory framework we might actually fit climate-related disclosures. And I might just invite my colleague Geoff Hoffman now to join us to discuss what some of those unique issues are in Australia and some of the ways in which it's thought that they might be addressed. Geoff, I'll pass over to you.
Thank you, Brendan. And thank you to Simon and Sarah for your outline of what's happening in the UK and the EU. As Brendan said, it's really just a matter of when, not if, the sort of mandatory disclosure of sustainability-related matters, and specifically climate risk matters, being the first cab off the rank, commences in Australia. And there are, I think, three issues that are exercising companies' minds here in Australia regarding what the consequences of that might be and the best way to implement it. The first one is that Australian boards and executives have an allergic reaction to forward-looking statements because the law in Australia is quite unforgiving when it comes to forward-looking statements. The onus of proof is reversed in respect of forward-looking statements, so that if someone makes a forward-looking statement, then it is deemed to be misleading unless it is made with reasonable grounds, or to put it another way, it's made without reasonable grounds. It's deemed to be misleading, which means that financial forecasts, if it's inherently uncertain, then they're not published. And so financial forecasts, if they are made, tend to be very short-term, very heavily audited, and made only with extreme caution. Companies will rarely publish forecasts for longer than 12 months for this reason. And if you ask the CFO of an ASX 200 company to publish a forward-looking statement about the financial position of the company in, say, 5 years' time, they would generally be advised simply not to do so because of the inherent uncertainty. And so there is a great deal of concern about how you match that regulatory regime with a standard which requires inherently long-range projections in relation to matters which are inherently uncertain. So there's that issue. The second issue is that listed companies here in Australia also have a continuous disclosure regime, so that if you have forward-looking information out in the market and you become aware of circumstances that could have a material effect on the price or value of your securities, you have a statutory obligation to immediately update the market. So if you have a sort of a periodic reporting regime, as we do have currently in respect of historic information, then that's fine. You do your periodic reporting. And if you've got earnings forecasts out there, then you do need to monitor those earnings forecasts to make sure that if they're changing materially, you update the market. But in terms of forward-looking statements regarding climate risk, that does raise another question as to, if things change, do you need to update the market, and how would you update the market immediately? So again, there's a question as to whether there should be some sort of special mechanism for which applies to continuous disclosure in respect of these kinds of reports. And lastly, a topic that's close to the hearts of all directors and senior executives of Australian companies, and that is that there is a sort of a quite aggressive personal liability regime which applies to company directors and senior executives who fail to take reasonable steps to ensure that public statements are accurate. And so there's two levels to that. One is if these statements are being made just in the ordinary course, then there's effectively a potential civil penalty for directors who authorise the making of those statements in certain circumstances if they are misleading. But then there's another layer which arises because these standards and this framework's coming in under the auspices of IFRS, and the question is whether these IASB standards, if they're adopted, mean that these kinds of climate reports are included in the bucket of documents which are currently included in the financial statements of the company, because the financial statements of the company within our corporations law have a sort of a special place in terms of the obligations of directors and senior executives to make sure that those documents are accurate and properly prepared. And, you know, there have been cases in Australia where courts have held that, you know, those duties of the director to ensure that financial statements are accurate are in fact non-delegable. Yes, they can take advice from others, but they need to turn their own mind, make reasonable inquiries and have an understanding of what those statements mean themselves. So that the level of ownership of those statements by directors, if they are included in the company's financial statements, is higher. So they're the three issues which are currently exercising the minds of corporate lawyers and others in Australia regarding mandatory reporting of climate matters. I mean, you know, as we say, it's a matter of when, not if, but then there's a couple of sort of how questions that need to be answered as well.
Thanks very much, Geoff. That's great. Simon, you've touched on earlier on the taxonomy that's being developed in relation to sustainable finance. And I think, you know, the developments in the EU and UK are a good indicator of what's likely to happen in Australia. And it appears to me that Australian businesses, based on what you said, in particular asset developers and managers, will need to take a keen interest in that taxonomy that's being developed. Maybe you just want to expand on that slightly in terms of how it could be of relevance to Australian asset owners and businesses.
Yeah, absolutely, Brendan. And taxonomies are being developed, as you know, all over the world. The EU's version, though, is probably the most developed and most specific of the taxonomies that at least I've seen. So the EU taxonomy, as I mentioned, is a classification system that applies to underlying economic activities. So in principle, the way the taxonomy works is that every economic activity, and obviously a company might have several or even, you know, dozens of underlying activities, but for every one of those economic activities, the idea is that you can analyze that activity and determine whether it should be classified as environmentally sustainable or not. It's binary at the moment. So not doesn't mean it's unsustainable. It just means it doesn't meet the threshold for being environmentally sustainable under EU law. And the idea is that large EU companies, and as Sarah-Jane mentioned, many corporate groups that are doing business in the EU, even if not headquartered in the EU, the idea is that those corporates report the extent of their alignment. In other words, they give you a proportion of underlying activities that are aligned with the taxonomy. So they have to make this assessment for each of the underlying activities. And the idea and the expectation is that this will drive up demand by investors for assets that can claim at least some level of taxonomy alignment, that have got a taxonomy alignment score that's above 0, and obviously one expects the higher the better. And in the private markets, it's expected that doing some sort of taxonomy assessment will be part of due diligence for certain asset managers who care about the taxonomy score of their fund, because they've either committed to a particular threshold or because their investors are pressurizing them to increase their taxonomy alignment. So we do expect people to be thinking when they're acquiring assets, whether in the EU or outside the EU, whether or not those assets meet the EU taxonomy criteria. Taxonomy alignment is not straightforward. It's a very granular exercise. So you really have to pass 3 tests. First of all, the economic activity in question has to be making a substantial contribution to at least one of 6 specific environmental objectives. So there are 6 objectives. They include climate change mitigation, climate change adaptation, protection of biodiversity, and so on. And you have to be demonstrating in that activity a substantial contribution to the achievement of at least one of those 6 objectives. And to test whether or not that contribution is specific, there are thresholds laid down in the law. So it's not just, I've got a solar park, but it's, does my asset specifically meet these thresholds? Then you have to assess whether or not your activity is doing significant harm to any other objective. So, you might be making a substantial contribution, but if you're doing harm to another environmental objective, then you don't qualify. And finally, you have to apply minimum social safeguards to make sure your business is operating in accordance with international norms, like the UN Guiding Principles on Business and Human Rights, for example. So doing those assessments is not straightforward, but I think at least being able to demonstrate that an asset is eligible for inclusion in the taxonomy because its activities are at least in principle capable of compliance with the taxonomy rules, I think that will make an asset more attractive, at least to certain potential acquirers.
Sarah, could I ask you a question? You mentioned before that the EU regime was intended to or captured entities which had material business operations in the EU, and I was interested to know whether that regime then required reporting and that taxonomy to be applied to that business's entire global group as a result of that EU connection, or whether it was just the EU operations of that group.
Yeah, it's a really good question, one that we've come across before. And unfortunately, the answer is that if you meet the thresholds, so just as a reminder, 150 million euros of turnover in the EU, plus a large subsidiary or a branch, then you would have to report for your entire group, regardless of where they're located. So it is potentially a very significant, a big lift for companies, particularly that aren't used to dealing with these types of standards. The proviso is, 2 provisos. The first is that for non-EU entities, these rules are not going to be applying until the financial years that begin after 1st of January 2028, with reports due in 2029. So got a little bit more time to prepare, to put processes in place, and also to learn from reports that will have to be published in that interim period by EU entities. And the other point to make is that there is a provision in the CSRD that there could be some equivalent regimes where we will have some mutual recognition of international standards that are sustainability reporting regimes that apply elsewhere. So unfortunately, the Commission will have to make a decision recognising those other international reporting regimes as equivalent. We can't see that happening very widely, just because the European standards are so expansive in terms of both their coverage and also the double materiality point that I referenced a moment ago. So we'll have to see how that develops, but we're not hopeful that it's going to be a widespread recognition of regimes all around the globe that the EU recognises as equivalent.
Thank you. That is interesting.
Look, thank you very much for Simon and Sarah-Jane in joining us in our discussion tonight. Also thank Geoff for his contribution looking at the Australian perspective. We trust that you found this discussion helpful and useful, and please be in touch if you'd like any further information in this rapidly developing area. Thank you for your time.
Thank you, Brendan.
Thank you.
Thank you.